minutes for rebuttal.
Thank you, Counsel.
May it please the court, my name is Doug Leek, and I'm here on behalf of the plaintiff, appellant, beneficiaries, Robert Cavanaugh and Rachel Cavanaugh Gorby. Also with me is trial counsel in the probate court, Mr. James Spindler, and also in the back of the courtroom is one of the beneficiaries, Rachel Cavanaugh Gorby. On behalf of the beneficiaries, we ask that this court reverse the probate court's decision and then order the removal of the defendant, Joel Aberth, as both the trustee and the executor, and also order the return of all attorney fees that were paid to both himself and his law firm. The basis for reversing the probate court's ruling is that the probate court failed to follow the Ohio Trust Code and the probate court code and other rules of evidence and civil rules. It is because of the probate court's error that today the rights of and the interests of the beneficiaries remain unprotected. Accepting the findings of fact of both the magistrate and the probate court as true, it is undisputed that there were a series of breaches of duty, both as trustee and executor, by Mr. Aberth. Taken as a whole, these series of breaches constituted a serious breach. Let's look at those breaches that were pervasive and widespread before litigation and throughout the litigation. First of all, the primary one is a unilateral failure of communication between Mr. Aberth and the beneficiaries. There were times that he never responded to requests on behalf of the beneficiaries, which is well documented in all the exhibits and the letters asking for information. When he ultimately did respond to some requests, they were untimely or not responsive. For example, a primary issue that started at the outset in April of 2002 was the method of compensation that Mr. Aberth was going to have. For a long time, it was never communicated to the beneficiaries what that method of compensation was, and it's well documented that for well over a year, that was being requested. Total lack of communication. Then, at some point, attorney fees were paid to both his firm and himself. Never communicated to the beneficiaries, and the only way they found out was when they received a statement from a Baird account. And then it was asked of Mr. Aberth to explain the attorney fees, the compensation fee, etc., never communicated. So there was no communication, there was a failure of communication, there was a breakdown of communication. That is just one breach by Mr. Aberth. Next, with regard to the trust, it is undisputed that the trust required that distribution of the income be made quarterly or sooner. It is undisputed that that first income distribution to the beneficiaries was not timely made. It was not made until after counsel got involved and requested, what is the status of the distribution income? It was only after that request and untimely that that distribution was made. And additionally, with regard to that late distribution, it was never communicated as an explanation of why it was late. And the probate court found that to be a reasonable delay, but that's inconsistent with the mandatory language of the trust that distribution has to be quarterly. So the probate court found that to be a reasonable delay, which is not acceptable under the trust. Another breach of the trust was the manner in which the distribution was made based upon the net income. It was not followed by the guidelines of the trust. Third, there was a delay in taking control of $2.5 million in assets by Mr. Aberth. Baird gave him a list of 7 items that had to be produced to get control of the assets. And there was a major delay of 8 months, culminating in finally the death certificate being provided to Baird. So there was a delay in taking control of the assets. Next, with regard to the annual reporting, once again, there was a delay in the annual reporting. It's mandatory that it had to be by the end of by the fiscal year or within 1 year of date of death. It is undisputed that the first annual report wasn't until 18 months later, and once again, only occurred after litigation was initiated. And one of the reasons litigation was initiated was because of the lack of communication. For instance, it was after the failure to inform the beneficiaries of the attorney fees that the exceptions and the complaint were filed. So the annual report, undisputedly, was untimely and a breach of the trust. Next, then the subsequent reports that are required by the trust were insufficient. All that was sent were merely statements from Baird, PNC, First Merit, and the I-bonds. There was no explanation of the liabilities of the trust. There was no explanation of the compensation fees in those reports. So those reports in and of themselves were a breach of the trust. Next, with regard to probate court, there was inconsistent applications to the probate court and to the estate tax department of Ohio. On the application for administration form 4.0, Mr. Aberth listed that he was not a creditor. But at the same time, in the estate tax form submitted to the state of Ohio, he is listed as a creditor for $2,770. That is inconsistent, and that itself is a breach. Additionally, the filing of the fiduciary account document to the probate court. In that document, it's asked, what are the fiduciary accounts? Mr. Aberth listed none. However, we do know that $22,603 was paid to his law firm, of which $3,868 was for the administration of the estate. Once again, another breach and a filing with the probate court. Next, with regard to the trust and the investigation, or the investment strategies, in December 2002, Mr. Aberth welcomed counsel and Raymond Fogg, a close confidant and business advisor to beneficiaries, to have input into the investment strategies. Between December of 2012 and January 2013, the beneficiaries were being represented and asked to give their recommendations or their opinions on the investment strategies. One investment is very important. There was an investment of $100,000 into Locor, which on behalf of the beneficiaries, objection was made. However, that went ignored. In fact, while they were engaging the beneficiaries, both Mr. Aberth and the financial advisor, Mr. Finkus, while they were engaging them, they made that investment without any knowledge and totally ignored the wishes of the beneficiaries. Another example of a breach of the trust. Next, over the course of the couple years, there were unilateral withdrawals for attorney fees in the amount of $256,000, which is an enormous amount in light of the fact that over the same period of time, the beneficiaries only got $71,000 in income, less than 28% of what the attorney fees were. Another breach of the trust. And then lastly, another example of this series of breaches is the IOTA account, upon which the probate court recognized as a breach, but only called it de minimis. What happened was that Mr. Aberth commingled probate and estate funds into his IOTA account.
Well, I was going to say two things with regard to that with the attorney fees. The court said under Article 10 of the trust that it was permissible and there was no limitation on the attorney fees. So if that's a part of the trust, how can that be a breach?
Well,
And then the court, and I'll follow up with, the court said there's no commingling. So what are we to do with that?
Okay. Well, we have to look at, first of all, under the probate code, revised code 5810.02, we take issue with those attorney fees to begin with, because any attorney fees associated with the breach of the trust are not warranted. We also take issue of the way they were paid without notice, without explanation, without full disclosure of attorney fee compensation rate. So that's where we take issue with the attorney fees.
So you're not disagreeing that they had ordinarily, they would have the right without authority of the probate court? This was not something you had to apply to probate court for payment of attorney fees?
That's our other challenge to these attorney fees.
Well, that's what I thought you were
Right.
saying in the briefs, but then I thought you were saying something different
Okay.
today, so. I'm
Number one,
confused.
we have issues with the way that they were taken, which constituted a breach of the trust. Okay. But secondly, with regard to the award, the beneficiaries were denied due process and notice. They just summarily approved the attorney fees, the magistrate and the probate court summarily approved them without any notice or opportunity to challenge them. And we have to look at the record there, because before the hearing in April of 2015, on April 1st, the probate court explicitly said that attorney fees will only be considered upon application for fees. Then on the second day of April, the next day, before the hearing, the probate court explicitly stated that the hearing will only deal with the substantive issues and that the attorney fees issue will be halted at that time. So we take issue as a breach of the trust of the manner and the way it was taken, that the attorney fees were taken. And then from a due process standpoint, that we didn't have our day in court to challenge those. So with regard to the breach of the trust,
Counsel, I want to ask you too, you have about 3.5 minutes,
Okay.
do you want to save?
I'm still going to go with the 3 minutes, I may go a little bit into it. With regard to the breach of the trust, Revised Code 5807.06 demanded the removal of Mr. Aberth. We pursued the removal under B1 and B3 of that provision. First of all, a serious breach of the trust, which the court found did not exist. Under B3, the unfitness and the unwillingness and the persistent failure to administer the trust. That part was never addressed by the probate court, and that was one of our issues. For all those breaches, it fell under B3. But also under B1, it was a serious breach of the trust. 5807.06 is modeled after Section 706 of the Uniform Trust Code. And communication is a key. But more importantly, a serious breach of the trust can be a series of breaches of the trust. Taken alone, each one may not constitute a breach, a serious breach, but taken as a whole. And we have breaches for communication, conflict of interest, the attorney fees issue. Those are breaches. So under B1 and B3, as a matter of law, the trial court or the probate court was required to remove Mr. Aberth. And then also, as the executor must have been removed under Revised Code 210924 of the probate code. Those violations that we talked about, the misfiling of the probate court files, the state tax forms, and the fiduciary account, for that reason too, should have been removed as an executor. So we have a series of breaches that constitutes a serious breach under B1, and also the unfitness, unwillingness, and persistent failure to pursue or to administer the estate. And most importantly, it's in the best interest of the beneficiaries. And that's why we're here. And one of the reasons we raised the parole evidence and hearsay issue, where they allowed the testimony about issues about Mr. Fogg, is very important, because the probate court decision is tainted by focusing on the conduct of Mr. Fogg, who is a confidant, close friend, and business advisor to the beneficiaries. And when you look at the decision, they focus on him paying attorney fees, which, number one, is irrelevant to the breaches of Mr. Aberth. And he's entitled to pay those attorney fees. It doesn't matter. But the decision is tainted by that parole evidence and hearsay regarding Mr. Fogg, and it's evident throughout the four corners of the decision. And for this reason, we find as a matter of law, the probate court was required to remove Mr. Aberth as both the trustee and the executor. We also ask that this court have the award of attorney fees vacated and returned to the trust. For that reason, we ask that you reverse the probate court decision.
Thank you.
Thank you.
Proceed.
Good afternoon. I'm John Suzanni. I'm with the firm of Stark & I'm here with my colleague Cavanaugh, and we represent Joel R. Aberth, Jack Aberth as he's known in the community. That's him sitting back there in the room. And we are asking this court to affirm the probate court's decision. It's clear that the appellant in this case wants to retry the whole case right now. We had a 5-day trial in this case. I think there were a dozen witnesses, over 150 exhibits. Of those dozen witnesses, 6 of them were experts who provided expert testimony. All of the things that my opponent, Mr. Leek, has provided here and now were addressed. And, we can go down the list one by one, but I want to preface that by saying one of the things I think the court found compelling was that all of the assets in the trust were protected. When they say, he took some time to get control of the trust remained with Aberth Financial where it had sat for 18 years prior to Dr. Cavanaugh's death. And then when Mr. Aberth took over, he did his due diligence about Aberth Financial. He'd never worked with them before. He considered whether or not he would use George Finkus. He looked at his past returns. He interviewed him about his investing philosophy, and he kept him on board. So it's not like when he said Mr. Aberth refused to take control of these assets, they remained right where they were. They were in the Baird Trust account, which had performed admirably and continued to perform admirably. Now, the other thing I think that's important, we're not here, even though the initial complaint and the exceptions talked about the possible misappropriation of assets. That never happened. The 2 beneficiaries admitted that in cross-examination, but yet that still hangs out there on the complaint that Mr. Aberth possibly misappropriated assets. That never happened. Their expert, Judge Donnelly, said there was no basis for a fraud claim in this case. So you'll wipe out these big things and they focus on, a series of breaches, as they call them. And they're trying to get Jack removed by, the proverbial death by 1,000 cuts. Let's start one by one. They talk about that the first distributions weren't made for 7 months after.
Before we get back into the one by one of what happened, what is the response to the allegation that not just that as a matter of law breaches occurred and the probate court was required to recognize them, but as a matter of law, the probate court was required to remove the trustee and the executive? And I realize that's 2 questions.
Okay.
Because the executor and the trustee are two different hats, but they are not arguing, at least it's my understanding of what I'm hearing, that the the court abused its discretion by failing to do so, but that as a matter of law, the court was obliged to absolutely remove.
Well, that's contrary to the case law. I mean, if you look at Deemer and even Bernard from this court, the standard is an abuse of discretion. And the court looked into all these matters. I mean, they're trying to say the court misapplied the law. It didn't. It looked at all of the claims that the appellants brought one by one. They had the benefit of 3 experts who opined about each of these things. There were countervailing experts. The judge in that instance had the ability to weigh the testimony and did, and issued an opinion which the probate court adopted. The standard is not whether the law was followed or not. It's an abuse of discretion standard in this case. And beyond that, the court did follow the law. If you look closely at the trust code, the trust code gives great latitude to the court. There's no place in the trust code where it says they must remove a trustee. It says they may remove a trustee, and it imposes a question of reasonableness upon the actions of the trustee. The court considered all of these issues. Every single issue that Mr. Leek presented to you today were exhaustively addressed in 5 days of trial, and by each of the experts. And they found 1 breach. I mean, that was the opinion. They found 1 breach. It was, as the court said, it was de minimis breach. Jack Aberth initially put some trust monies, $12,000 I believe it was, into his IOLTA account. It was spent on trust bills. An accounting was made for it. It was provided to the appellant's attorney, Mr. Stimler. And, there's no question that he misappropriated that money or did anything else. The money was in there for a temporary period of time, and then went into the rest of the trust, whatever was not spent. was it. That was the one breach. That is the only breach the court found after addressing every single one of these questions. And to say that the court didn't opine about his fitness or his willingness to administer the trust, the court found specifically that Aberth had paid out every cent due to these beneficiaries. And the one thing I do want to slip in here is this case is brought by 2 beneficiaries, but there are 3. And the 3rd beneficiary has a very different interest than the 2 beneficiaries who are here today. The 3rd beneficiary, the remainder money, is the University of San Francisco. Dr. Cavanaugh, for reasons his own, decided to give his children only income during their lives. The remainder of the state goes to the University of San Francisco. So it's not like, Jack can just dole out money willy-nilly to the children, the beneficiaries, the income beneficiaries. He has an obligation to protect the trust, to protect the assets for the University of San Francisco. And the university gets overlooked in this. It's a charitable institution, as they often do in cases like this, because they don't send lawyers to appear and participate in the case. However, the trustee and the trust advisor, Mr. Finkus, who does the investments, they have to worry about that, and worry they did. And the other thing that the appellants aren't telling you is that we provided an expert, Mr. Doug McKay, who's a financial expert, an investment expert. He runs mutual funds. He is a frequent guest on CNBC and Barron's, and he testified, and he has no interest in this trust or in this lawsuit. He testified that the trust investments by Mr. Finkus had done admirably well in a conservative environment where you have to invest conservatively because you're protecting the beneficiaries. The trust has continued to do admirably well. Mr. Aberth monitors it. He continues to kick off income at about 4% a year to the income beneficiaries. One of the big fights in this case was a disagreement from Mr. Fogg and Mr. Aberth early on in July of 12. Mr. Fogg disagreed with Mr. Aberth's definition of what constituted trust income. Mr. Aberth told him he would be distributing all the interest and dividends. Mr. Fogg insisted that he wanted growth included. And Aberth said, no, I can't do that. I got to have something left over for the University of San Francisco. That's when the real dispute began. That's the July 23rd meeting. And the meeting went badly. If you look at the transcript, Rachel Gorby, who is one of the beneficiaries, said Mr. Fogg, who was her mother's long-term boyfriend, commandeered the meeting from her. That's the word she used. He started asking the questions Aberth answered. And I asked her, did Jack answer all the questions as best he could? And she kind of wiggled around, but in the end she said, yes, best as he could. That was the crux of the dispute. They didn't like the distribution. But let me tell you another thing. The trust itself, at Article 10, Section B, specifically and exclusively gives the power to determine what is interest to the trustee. That's Mr. Aberth. And it said it is conclusive against all parties. Now, this trust also had an anteriorum clause, which meant that if anybody challenged the trust or the terms or how it was implemented, we could have sought to disenfranchise them. Aberth didn't. So all this talk about this bad feeling toward the beneficiaries is malarkey. Didn't happen. Every time they asked for money, Aberth gave it to them. There's not one instance where they asked for money that they were refused. The only extraordinary request came from Robert Dornan Cavanaugh. He asked for money to pay for his wife's medical bills. The trust did not call for that. She is not a beneficiary of the trust. But Mr. Aberth, using his discretionary authority, invaded the trust, paid her medical bills to satisfy the beneficiary, Robert Dornan Cavanaugh. The other time Mr. Cavanaugh asked for an extraordinary bequest was when he was on sequestration. He's in the Navy. He missed work. And so he wanted some money to make up the shortfall. Mr. Aberth paid him. There's no dispute. There's nothing in the record that says otherwise. So Aberth has paid every cent to them to which they were entitled. Aberth has protected the assets. The trust has grown. An outside expert says it's done remarkably well. These are the facts. These are what they're trying to obscure by pointing to these gotcha moments. He put money in IOTA. Yes, he did. They didn't lose a cent. The first payment was delayed 7 months. Aberth said because he was waiting for the will contest period to expire, that's 6 months. Also, one of the other things they didn't tell you is he requested information from the beneficiaries about the bank accounts and the assets of Dr. Cavanaugh. Ms. Gorby handled his assets prior to his death. At the July 23rd meeting, Mr. Fogg for the first time talked about property in California. We knew nothing about that. And we didn't want to distribute until we knew what that was, whether there were liabilities, whether it was rental property, whether it was investment, how much was there. We didn't get that information until September. And after Robbie Cavanaugh had to write to his mother and tell her to get Rachel moving to get the information of the trustee so we could get the ball moving. That's what Jack Aberth did, and to this day, payments continue monthly. And Jack sends them payments monthly with a letter explaining how the interest is broken down. And all this stuff about attorney's fees, that was addressed, and Mr. Lee talks about that they were taken unawares, but that's simply not true. They filed a motion asking to force us to disgorge attorney's fees. And that was addressed by the magistrate on February 12th of 2015. And an important part I'm going to read to you, so if you bear with me. Plaintiff's prayer for relief requests that all payments for litigation expenses be voided and reimbursed, that no further disbursement be made from the trust during the pendency of the litigation, that the court approve any further disbursements, and that Aberth provided documentation by way of invoices for all litigation expenses. Items 1, 2, and 3 are denied, so that was to return money. Item 4 is allowed, which we had to give new invoices about our fees. Aberth shall provide plaintiff's counsel with all documentation relative to payments made from the trust for past and future litigation expenses redacted by Aberth to protect any privileged work or product information. He then goes on to say, and this is important, if it is finally determined that Aberth has breached his fiduciary duty or is found to have committed any other misconduct, the issue of Aberth's payment of attorney's fees and litigation expenses from the trust will be reviewed by this court. That was the magistrate's decision on February 12th of 2015. Judge Stormer adopted that hearing and agreed that the issues would be heard at trial on April 2nd, and she said all substantive issues. Attorney's fees was a substantive issue. Mr. Lee quoted that, the April 2nd order. That was a substantive issue. That was the issue. It was removal and fees. They wanted to get the fees back. Now, let me address one other thing. I know I'm probably getting late on time, but this issue of hearsay. Well, that's kind of funny, because when these statements were uttered in trial, there was no objection to them. So any objection to whether or not that was hearsay or parole evidence or not should have been addressed at the trial. It was not. And I can send you that position in a moment. When Mr. Finkus was discussed, saying that Dr. Cavanaugh wanted Finkus to do it, at page 649 in the transcript, there was no objection by Mr. Stimler. When it was said again, Dr. Cavanaugh wanted Finkus, on transcript page 767, there was no objection by Mr. Stimler. When Dr. Cavanaugh said, when he warned of Fogg's interference, there was no objection to that, page 844. Now, this is a total red herring, because, and it's instructive, when you look closely at their brief and their issues of assignments of errors and issues, they have 5 assignments of errors, including this hearsay one, and then they have 4 issues. The hearsay is not addressed, or so-called hearsay or parole evidence, because it wasn't. There was nothing there. Whether or not Cavanaugh said, keep Finkus, who cares? That's not rewriting the trust. Aberth had absolute discretion who he wanted to pick as a financial advisor, and he testified at trial at length about the due diligence he did before he decided to stick with Finkus. Aberth could have chosen somebody else, but he liked what he'd done. It's not like he was a favorite son. He'd never worked with the guy before. He was impressed with his 18 years of work with Dr. Cavanaugh, and he was impressed with his philosophy. Moreover, he also testified that he worked with them to restructure the trust, and Stimler and Fogg were invited, and they implemented. And Mr. Finkus, who again had no dog in this fight, unequivocally testified, when we left that meeting, it was full bore ahead. Now, Mr. Stimler, after the fact, wanted more information and things like that, but he was too late. And we had an exhibit at the trial that showed exactly the timeline, and showed, when he finally said, he never said don't buy these things, he just said we want some more information. Now,
Councilor Brown.
I'm sorry, I will conclude by just saying we ask to affirm the lower court's decision. It's an abuse of discretion standard, and they've not showed that the judge abused the discretion of the court. Thank you.
Thank you. You only have about 20 seconds.
First of all, there was no waiver. The transcript will speak for itself. The attorney fees, the April 2nd decision says substantive issues will proceed, attorney fees halted. They keep on talking about harm, damages. That's where the trial court, the probate court is wrong. That is not required. We pursued this under a serious breach under B1 and the unfitness and unwillingness under B3. They focus, just like the probate court did, on harm. We're talking about lack of communication and serious